Hello all, welcome to yet another live session of Narayana IAS Academy. So the topic that we've actually picked in for today has been a most debated as well as a most talked about topic. So this has been picked up from the Indian Express for Dignity in the End. That is, this particular article discusses about the recent Supreme Court judgment that was actually given with respect to this particular phenomena or the concept of euthanasia. So here it is important for us to discuss about what is this particular phenomena of euthanasia in India, and then what are the different types of euthanasia, whether it is active or it is actually passive, and which of the following has a legal provision under, or which has a legal provision or protection in India, as well as we will be discussing about what are the arguments for it as well as against it, and also we will be looking into what are all the ethical issues and the legal issues surrounding the same, and at the end we will be discussing about what has been the judgment that was given by the Supreme Court. Okay, so here we will be discussing about this particular topic of euthanasia, which is also known as mercy killing, and also right to life, that is under Article 21 of the Constitution, and what has been the interpretation of the Supreme Court with respect to the same becomes very, very important. So this entire topic can actually be mapped to GS paper 2 under the mains examination, specifically under fundamental rights as well as vulnerable sections of the society. Now moving forward, there has been a previous year question which was asked in the year 2015 with respect to that of Article 21 of the Constitution. So these kind of provisions, their constitutionality, the constitutional safeguards as well as the legal backing becomes very, very important for your prelims as well as your mains examination. Specifically, the analysis and how you actually give a neutral stand on the particular topic becomes very, very important for your answer writing for the mains examination. Now moving forward, let us actually understand what this particular topic is actually talking about. Okay, so there has been a recent Supreme Court judgment that was brought out, and this actually talks about the legal as well as the ethical confusion and the dilemma, the debates that have been revolving around euthanasia in India. For that, it is very important for us to first understand what the judgment has actually been about. Okay, so recently what happened, there was a judgment that was given by the Supreme Court which actually involved a person named Harish Rana. He is a 32-year-old and he has been in a vegetative state for almost a period of 11 years, where the doctors have actually they had actually declared that he had very, very mild or nil chances of recovery or survival. Okay, so in light of this, or in this backdrop, his parents had actually sought permission in order to remove the Ryle's tube. What do you mean by this Ryle's tube? This is nothing but a device which was used to feed the person, okay, through the nose, and then it actually takes the food to the stomach. So this was the Ryle's tube, in order to allow him to die naturally and with some dignity. Okay, now what happened? Now the Supreme Court actually, after analyzing this issue, had actually come out with a judgment. So on August 20, 2024, a bench was actually headed by the Chief Justice of India, Mr. D.Y. Chandrachud. He actually denied the request by the parents, ruling that the Ryle's tube actually is not eligible, or it is not, it does not fall under the category of, what do you say it as, the life support system. Okay, because if you see, in 2018 the Supreme Court had already given a judgment saying that the life support system in terminal cases can actually be withdrawn, thereby allowing passive euthanasia on case to case basis. However, here the Supreme Court has actually ruled that this Ryle tube does not fall under the category of the life support system. So this is what has happened. So here, having understood the background of the recent Supreme Court's judgment, now it is important for us to understand what is euthanasia. Okay, so euthanasia is often known as mercy killing. So this actually refers to the practice of intentionally or voluntarily ending the person's life in order to relieve them from the incurable diseases or unbearable prolonged suffering that they have been undergoing for a prolonged period of time. For example, the previous case, the person was actually suffering for a prolonged period of 11 years. Okay, so in order to take away the unbearable suffering, what happens is that there is a voluntary inculcation withdrawing of the life support system, that is called as passive euthanasia, that is painless and dignified. So, euthanasia is basically of two types. One is active, where there is voluntary and direct administration of lethal drugs in order to take away a person's life, which is actually not allowed in India according to section 302 of the Indian Penal Code, that is the BNS. Whereas the passive euthanasia, this actually involves withholding or withdrawing the medical treatments that are necessary in order to keep a person alive. Okay. Now, if you see what is the status or the legal provision under which this euthanasia is actually protected in India, in case of active euthanasia, it is not allowed in India, and it is prohibited under sections 302 and 304 of the IPC. Whereas, if you see passive euthanasia, that is actually permissible under specific conditions officially recognized in India in 2011. If you see this particular infographic on my screen, this actually talks about the chronology of instances where the Supreme Court has given its ruling with respect to that of passive euthanasia, and it is actually spoken about the correlation that this particular euthanasia has with Article 21 of the Constitution, which actually gives you the right to live with dignity. So, in 1996 in Gyan Kaur versus the state of Punjab 1996, the Supreme Court actually held that the right to life under Article 21 does not give you the right to die. So, this is very, very important. And after a decade or so, in 2011 in Aruna Shamba versus Union of India 2011, the Supreme Court actually held that passive euthanasia can be allowed under exceptional circumstances. Okay, when there is a vegetative state, or where there is unbearable pain for a prolonged period of time, where there is no chance of recovery, then what happens is that under exceptional circumstances, passive euthanasia is actually allowed, is what the court said in 2011. In 2016, the Medical Treatment of Terminally Ill Patients, Protection of Patients and Medical Practitioners Bill 2016 was actually introduced, that makes or gives a provision to the patients of sound mind in order to make an informed decision regarding withholding of the medical treatment for themselves, paving the way for implementation of passive euthanasia in the country. And in the latest ruling in 2018 in Common Cause versus the Union of India, the Supreme Court held that a person in persistent vegetative state can opt for passive euthanasia, and that the person can execute a living will to refuse medical treatment in case of terminal illness. Okay, so that is, a person can actually write a living will saying that they can actually take up this passive euthanasia in case of terminal illness. So, that is what we will be looking at, the 2018 Supreme Court judgment in Common Cause versus the Union of India. This actually gave in certain stringent requirements. So, in case if somebody wants to actually implement this particular passive euthanasia, what is required? The creation of a living will in the presence of two witnesses is required. Who are these witnesses? One, it needs the authentication by a judicial magistrate, and number two, it requires approvals from two medical boards and the jurisdictional collector. And what is a living will? This actually allows a patient to give advance consent. Okay, so a person advance, when he is in a stable state of mind, can actually give a consent by writing a will for withdrawing the life support in case if they fall into a permanent vegetative state with no prospect of recovery. So, this is called as living will. But what are the challenges that were actually noted with respect to that of the 2018 judgment was that it was felt that there was complexity and it was very, very cumbersome, because since the enactment in 2018, no family was actually able to navigate the bureaucracy to get this entire process of passive euthanasia done. The second one, the time sensitive decision making is not accommodated by the procedural requirements, and it often needed urgent situations at the ICU settings, and also there was actually financial exploitations by these hospitals, where the hospitals would actually continue to give the vegetative support because they can actually fleece money from you for their own financial gain. Now, following all this, in 2023, the Supreme Court had actually come up with certain guidelines in case of passive euthanasia, where it actually said for terminally ill patients, we are actually making it more accessible and less burdensome for the families or the caregivers of the patients in critical conditions. Okay, so the changes were actually brought. So if you see over here, with respect to that of living will, earlier it was said that it was necessary for a judicial magistrate to attest or countersign a living will. However, later in 2023, an attestation by a notary or a gazetted officer to be sufficient for a living will. Next, access to the living will was earlier, it was kept in custody of the district court concerned. However, later it was to be a part of national health record which can be accessed by the Indian hospitals. With respect to the primary board that will be constituted in order to examine the patient's condition, earlier it has to have doctors, at least 4 experts from the general medicine, cardiology, neurology, nephrology, oncology, etc., with overall standing of at least 20 years, whereas the latest one says that 3 doctors including treating physician and other doctors with 5 years of experience in the specialty will actually comprise the primary board of directors. And if you see the secondary board also, earlier the district collector had to constitute the secondary board of medical experts. However, currently the hospital must immediately constitute a secondary board of medical experts. And moving forward, time taken to decide. Okay, so earlier the 2018 judgment, it was very concerning that it does not specify any kind of outer limit within which it has to be taken, a decision has to be taken or arrived at. However, currently primary or the secondary board shall actually decide within 48 hours on withdrawal of any kind of further treatment. Now, having discussed about what is the concept of euthanasia, what has been the judgment and what has been the chronology of the instances where the Supreme Court had come out and spoken about the allowing this particular practice in India, it is very important to actually see the other side of the coin. However, it actually feels a progressive step. What are at the same time the challenges or the concerns revolving it is that first is there is medical as well as ethical confusion, okay, because there is no clear cut demarcation of what actually stands as a life support system. So, the judgment raises the concerns about what constitutes the life support system, challenging the ethical principles like the non-maleficence, the justice and the autonomy. And here there is actually a tussle which is going on between sustaining the life or prolonging the suffering. So, sustaining life versus prolonging the suffering is actually being questioned or criticized. Next one, there is a huge impact on both the patient as well as the caregivers, because the criticism focuses on potential unnecessary prolongation of the suffering for both the patient as well as his or her caregivers, reflecting the societal fears and also the misunderstandings and apprehensions that is actually revolving around passive euthanasia. And finally, there has to be a need for a legal clarity. That is, the case highlights the necessity for the clearer legal guidelines in order to distinguish between euthanasia as well as withdrawal of non-beneficial life-sustaining treatment, suggesting a greater role. So, they are saying that a greater role of both the medical experts as well as the ethical experts have come together in such decisions in order to protect the rights of the patients to a dignified life as well as death. So, here this is where we have actually discussed about the most trending topic of euthanasia, which also is important for your paper 4 ethics. So, I hope you have actually enjoyed this live session. So, for more updates as well as interesting topics to actually come up in the live sessions, please do like, share and subscribe to Narayana IAS Academy YouTube channel. Thank you and have a good day.